But I do want to ask you whether you notice whether anybody is absent from this list. I'll just go through it slowly again. It's absent.
Is education there? Prof?
Education can expropriate, Chair.
Okay. Oh, good. But in that list, I think James, all right, yeah, you're right. Have you lost the professor? Yeah, we have lost the professor. For now, I see he's gone. Maybe we can just probably just wait a bit while the prof is trying to reconnect. Thanks, Prof. You are back. We lost you. Can you unmute, Prof?
Yes, thank you. I hear you. We were here thinking about who is absent from the list of departments with the power to expropriate.
All right.
Local government.
Yeah, local government we don't have there.
Okay.
Yeah, we'll look at that now. Yes,
Yeah.
so another one is where is it now? Another one that is absent is the Minister of Police.
Oh.
So this is so the Municipal Systems Act provides powers of expropriation at the municipal level, which I suppose can take care of some of what local government needs. The Minister of Police doesn't have the power to expropriate, not in terms of the acts applicable. And I suppose that is because there are other powers of that are assigned to the Minister of Police for those kind of powers, but very importantly also police power was the ability to protect the freedom and the property of the people. Eminent domain is the power to take the property in the interests of the public. So this is where I would like to leave you, Chairperson. I am going to hand over to Dr. Richard Kramer. And I am also going to try to create a backup source of Wi-Fi in case the problem is on our side. So I will just turn this around so that Dr. Kramer can see.
Thank you, Prof.
There we go. Get back to
the floor is yours, Dr. Kramer.
Good morning, members of the committee. I will now be discussing what exactly can be expropriated, looking at both land as well as other constitutional property. So the starting point, I think, has got to be, what does the bill mention? What property in particular does the bill mention? The bill empowers expropriate property, but what exactly does it mean? So the starting point obviously would be land. The bill has a number of clauses which concern land specifically. For example, a clause which concerns valuation and investigation purposes. There's also a clause which requires consultation with municipalities and other organs of state that may be affected by expropriation of land. And also where land is expropriated, there are additional notice requirements, additional parties who need to receive notices of intention to or a notice of expropriation. And obviously land in the current bill, there are specific clauses related to compensation which specifically relate to land. So land is a form of property which is explicitly mentioned in the bill. And the clauses that concern land are mainly procedural. But ultimately, land is not the end of it. Land is not the limit of the kind of property that can be expropriated in terms of the bill, even if it is perhaps the most important. So that requires us to consider what exactly is meant by property in the expropriation bill. The expropriation bill defines property as contemplated in section 25 of the Constitution. So the bill itself has an open-ended definition of property. It doesn't give us a comprehensive, detailed definition. Instead, it points us to the Constitution. This is like one parent telling their child who's asked them for something to rather go ask their other parent about it. So then we are now pointed to the Constitution. And how does the Constitution define property? All the Constitution does is tell us that property is not limited to land. So ultimately, we have two very open-ended definitions of property. We have, on one hand, the expropriation bill, which tells us that property is property as contemplated in section 25 of the Constitution. What's happening? Oh, sorry, I didn't realize you hadn't shared the screen.
I think the screen sharing.
How do I get back? Sorry, everyone, I didn't realize the screen share had been turned. The computer was passed to me.
We also neglected that because we are very audible. We could hear, we could follow you.
Okay. What can you see now? Yes.
We can see now.
Okay, you can see the screen now. So let me just go back and show you my previous slide. So that was the previous slide dealing with land. And now we've come to this open-ended definition of, we have this open-ended definition of property in both the expropriation bill and the Constitution. The expropriation bill just points us to the Constitution, which itself simply defines property as not being limited to land. So ultimately, we don't have a comprehensive, detailed definition of what exactly is property for both the expropriation bill as well as the Constitution. So that means we now need to start thinking about what exactly is constitutional property. The easy example is physical property, which aligns with the private law, property law definition of property, which
we sort of lost you again, Prof. there is an intermittent disruption.
Switching on the audio on this side. Maybe you can continue talking.
Can you hear me now?
I suspect
this one's just the connection.
yes, yes, you are better now.
The screen is still shared.
Yes.
Screen shares died. Try to switch over to my laptop.
I don't think it will make a big difference.
Is everyone else? Yeah, we're not hearing anyone else at the moment either.
Yes, we can continue because anyway, we have the presentation. If the
Connection is good. Let's go to Eduroute and see what's better.
Doc, are you still there?
Recording in progress.
Can you hear me again?
Yes, we can hear you. Yes, we can hear you. We can see the screen. You have disappeared again. Am I the only one?
Say that again.
Can you hear me? Okay, can you hear me now? Can you hear me now?
Yes, we can hear you, Dr. Kramer.
Okay, so ultimately we need to consider what exactly is constitutional property. Property for the purposes of Section 25 of the Constitution. An easy example would be physical property, corporeal property, as we were talking property law. So physical property, in private law, the law of property is primarily concerned with physical property and the rights people have in physical property. For example, your car. The car is an easy example of property that would be considered, your ownership of your car would be considered constitutional property. But the Constitutional Court has said in FNB versus SARS decision that it's not possible, and it is judicially unwise to provide provide a comprehensive definition of constitutional property. So ultimately, what is constitutional property will usually be decided on a case-by-case basis. We can provide some examples of non-physical, intangible property that have been or would easily be recognized as constitutional property. For example, rights to minerals granted in terms of the MPRDA, other limited real rights in lands such as servitudes. The Constitutional Court has also acknowledged a claim for unjustified enrichment to be constitutional property. And this means that debts or other claims that sound in money would likely be considered constitutional property as well. We've also had a case in which the Constitutional Court has acknowledged a liquor license to be property for the purposes of Section 25 of the Constitution, meaning that a liquor license would be protected against arbitrary deprivation. And then intellectual property or shares in a company would be quite easy examples of constitutional property. So while physical property is the heart of constitutional property, it is ultimately not the limit of constitutional property. We have a lot of non-physical, intangible rights that are increasingly economically valuable. And thus, it is necessary to protect those rights as constitutional property, as acknowledged by the Constitutional Court. And this includes even a right such as a liquor license, which is usually subject to administrative cancellation, amendment, and regulation. So, we've defined constitutional property, but what exactly can be expropriated? Can anything that is considered constitutional property be expropriated? The bill does facilitate the expropriation of property in general, and defines property as property for the purposes of Section 25 of the Constitution. But not everything that is considered constitutional property would necessarily be property for expropriation. The concept of constitutional property is very wide and includes rights which will likely never be considered in an expropriation context. It's easy to conceive of a car or land being expropriated, but how exactly would a liquor license be expropriated? Can it, in fact, be expropriated? Since the state usually regulates a liquor license through administrative law. So we have rights that are acknowledged as constitutional property, but might not necessarily be property for expropriation or ever be considered in the expropriation context. You have the easy examples like your car or land, but then we have the more tricky examples like a liquor license, which doesn't seem to really fit with property for expropriation, even if it is acknowledged as constitutional property. Why is this? Well, this comes down to the state acquisition requirement. Property in the bill is constitutional property, but constitutional property requires something more to be property for expropriation. This is the state acquisition requirement for expropriation. And ultimately, for a right to be property for expropriation, a right must be capable of acquisition. This means that in order for expropriation to occur, you must have, on one hand, a right that is considered constitutional property, and on the other hand, the state must acquire the substance of that right as per the Constitutional Court in Agri SA. So we have a situation where for simple deprivation to rise to the level of an expropriation, you have to have both constitutional property and the state acquisition of the substance of that right or property. So this is as simple in the case of physical property. It's always possible for the state to acquire the substance of the ownership of land or the ownership of a car. But it's a bit more difficult when you get to the example like a liquor license. A liquor license has been acknowledged as constitutional property and is protected against arbitrary deprivation. But it's hard to conceive of how exactly the state could expropriate a liquor license. The state may withdraw, amend, or cancel a liquor license, but by doing so, it does not acquire the substance of such a right. So ultimately, the state acquisition requirement seems to operate as a brake on what kind of constitutional property can be considered property for the purposes of expropriation. So this brings us to the state acquisition and expropriation checklist. This provides a breakdown of state acquisition and expropriation. So we start with constitutional property. When we have tangible property, the substance of a right, for example, ownership, can always be acquired by the state. And thus, it's always easy for tangible property such as land or car to be property for the purposes of expropriation. When we get to intangible property, it's a bit more tricky. There are a number of intangible rights, such as limited real rights in land, where all shares in a company, where it's very possible for the substance of that right to be acquired by the state, and thus such rights can be property for the purposes of expropriation. However, in some cases, such as a liquor license, it's very difficult to conceive of how the state can acquire the substance of such a right that it usually can, through administrative law, regulate, amend, or cancel. The simple deprivation of a liquor license is very unlikely to ever rise to being an expropriation. So we have a very wide concept of constitutional property, but not all constitutional property is necessarily property for expropriation when you consider the requirement that the state must acquire the substance of a right. In not every case, not every right that is recognized as constitutional property can be acquired by the state. And that's where I'm going to leave off and hand over to my colleague, Mr. Matiba, who will deal with when is it exactly expropriation.
Greetings, members of the Select Committee. Thank you once again for the opportunity. My name is Hapalelwe Matiba, like Prof. Mostert has already introduced me. I would assume that at this point, we have already been taken through the different types of rights that can be expropriated by my colleague, Dr. Kramer. And earlier on, Prof. Mostert has laid a very detailed theoretical background and history of where does this power to expropriate actually comes from. And we are sitting here now today and we are deliberating upon the expropriation bill. And now one may want to ask what exactly is expropriation and when is it expropriation? So it is exactly what I will be contributing towards this discussion to explain what expropriation means, the different elements or definitional elements of expropriation, and how expropriation actually differs from other forms of acquisition of ownership. And when I was busy, preparing for this session, I thought I should just put this picture there. And you would see this picture actually depicts what actually expropriation would look like in the real world. You would see there are three arms of what seems like to be three gentlemen wearing suits. In a real world, those three arms would depict the state in the form of an expropriating authority. And you would also see three human beings there. The man who was, I would assume he was busy working the land. That seems to be a very well taken care of piece of turf. And the state is forcefully grabbing that land. And you see down here, there's a lady wearing purple, holding what seems to be a spade and pointing fingers, demonstrating aggression and anger. So that is basically what plays out in the real world, in the ground, whenever expropriation gets to be executed. Now, what is expropriation? In very simple terms, expropriation involves the unilateral state action that entails the acquisition, the compulsory acquisition of property, either in part or whole, that belongs to a private owner or any person who has a claimable right over that particular property for the purposes of public benefit, public use, or public interest, or in the public interest. That is basically what expropriation means. And I must emphasize the point here that at the center of expropriation, like Prof. Mostert highlighted earlier when she was dealing with the theory behind expropriation, lies a very critical element of public use and fairness. So those two elements play a very major role in determining the legitimacy of any expropriation act. Now, this brings us to this expropriation as deprivation. So Section 25 of the Constitution is clear in saying that no one may be deprived of their property and that no law may permit arbitrary deprivation of property. Now we see here that in our current legal framework, the Constitution and other subsidiary legal framework provide for different forms of deprivations. And expropriation is just a sub-theme or subset of that host of deprivations. Now, like I said, that Section 25(1), it provides that no one may be arbitrarily deprived of their property. The section does not really go beyond that. Even the Expropriation Act itself, it doesn't go beyond that to actually explain what exactly is deprivation. But then in the vast theory, the property law theory has actually over the years come to acknowledge or recognize that there are two different types of deprivation. The deprivation may be substantive in nature or otherwise procedural. There's no clear differentiation or distinction of between these two in the law. But then our jurisprudence, the Constitutional Court in particular, has contributed quite significantly towards building a knowledge-based jurisprudence that actually gets to guide when exactly can we say that deprivation is arbitrary in a substantial sense and also in a procedural sense. Okay, now this goes to the definitional elements or characteristics of expropriation. How do we tell that this is expropriation? How do we say that this particular deprivation is expropriation? And these are the key elements that sets expropriation different from other modes of acquiring property. Like I said, in my earlier definition, simplest definition of what property basically would mean in a layman language, the first element is, of course, it involves the original acquisition of ownership, of which, like Dr. Kramer said, it usually involves land, although we know by now that constitutional property is not only concerned with land, but it can be interpreted more broadly. But we know that for the purposes of this bill, most of one would ordinarily be inclined to assume that property in the context of this bill relates to land, as it has been quite debated for some time now. So the first element is, of course, is an original acquisition of ownership that involves a unilateral state action. And what does that unilateral element mean? It means that the cooperation of the previous owner or the current owner of the property is not necessarily a requirement here. And I would take you back to this picture here that depicts expropriation in the real world. You would see this woman here who's pointing fingers and demonstrating a great deal of anger and aggression. You can clearly see that there's no form of agreement here or meeting of minds between the lady and the three gentlemen who are grabbing their land, who seem to be the expropriating authorities. So it's a unilateral state action in that sense. And I must also add here that the expropriating authority might actually, expropriate the land for public benefit, for public purpose, and it may actually get to later on make that property to vest on a third-party transfer for economic development, whether directly or indirectly. So that is the first element of it. It must be, lead up to the original acquisition of ownership. And the second characteristics is that the person executing expropriation must be someone who's acting on public authority, and the decision to expropriate is administrative in nature. And for that fact, it means that such particular decision, although it operates within Section 25, a realm of the Constitution, and of course the Expropriation Act, such particular decision must also satisfy the requirements that are stipulated in Section 33 of the Promotion of Administrative Justice Act. So the decision to expropriate must meet the PAJA requirements, just like any other administrative decision in a different context. So the person must be acting in public authority. It might be, we know by now that the bill actually vests or clothes the Minister of Public Works and Infrastructure with those powers, but then those powers, the Minister of Public Works and Infrastructure may actually get to delegate those powers to other organs of state, as the case might be. And then the third element is that the expropriation must only be executed if it has been established that the end result is for public purpose or is to benefit the public. So there must be a very strong element of public purpose or public interest. And this is where, like Prof. Mostert has argued earlier, this is where the legitimate justification of expropriation element comes in, to say, yes, we know that the state is vested with these powers to expropriate the compulsory takings of property, private property, but then to ensure that there is no misuse and abuse of this power, how do we actually guard against the state misusing this power? And this is where the legitimacy test question comes to play, and I will be explaining this shortly. And the fourth element is that expropriation must take place or must happen by operation of law. In other words, there must be an enabling legislation that provides or that authorizes such particular expropriation to take place. We have already took you through a vast list of legislation that clothe different departments with the power to expropriate. That is a good thing because it indicates that the power to expropriate by different departments, it is not exercised from a hollow, but there's actually the enabling legislation that provides for that. And then there's another element which is critical, and I think I've also quite emphasized this earlier when I was explaining the depiction there, that it oftentimes happen against private owners' will. What this means is that, like any, most of the original acquisition of ownership methods, it doesn't necessarily require the cooperation of the current owner of the land or the property. So it will happen forcefully whether the current owner is cooperating or not. And then the last element is, of course, as provided by our Constitution, Section 25, subsection 2, there must be payment of just and equitable compensation. This is, the best practice so far when compared to other jurisdictions that are also having a similar, mechanism of the power to expropriate in their constitutional property frameworks. So these are the main elements that sets expropriation different from other modes or methods of acquiring property in an original manner. Okay, I've indicated earlier that we have to guard against the legitimacy of expropriation actions so that the state does not actually get to abuse or misuse this machinery. And like I've said earlier, we know by now that expropriation is just a subset of a host of deprivations that are currently provided for in our legal framework. But then how do we know that a particular expropriation act is legitimate. In other words, it is done for good reasons, and it is not just the relevant state authority or the expropriating authority abusing or misusing this power. So our courts have established the legitimacy test for expropriation, which basically entails two legs. The one leg lies on the realm of rationality, and the other one lies on the realm of proportionality. On the rationality element of the test, what the court really would be obsessed with here is the suitability of the property that is targeted for expropriation to achieve whatever the intended objectives are for that particular expropriating authority. If the court is established, if the court is convinced under certain circumstances that the property that the expropriating authority is targeting to achieve a particular objective is sufficient enough, or meets what it would under normal circumstances consider as meeting the threshold of suitability, then such expropriating authority has went one step ahead towards proving the rationality of the decision to expropriate. So the property that is targeted for expropriation must be suitable to achieve the intended objectives that the expropriating authority have in mind when they start to execute or think about expropriation. And the second subrealm is the availability of sound reasons. Like I said earlier, the decision to expropriate does not just happen in a hollow space. There must be compelling reason, sufficient substantive reasons that goes to justify why expropriation, as opposed to any other form of, achieving whatever the intended objective might be. So for rationality leg, you have to, establish the suitability of the property to meet the intended objectives, and the sound reasons must be there. The court must be convinced with the reasons that the expropriating authority advances for the expropriation to take place. That is with the rationality. And then it comes to the proportionality, which is the second leg of the legitimacy test. The proportionality leg actually concerns itself with the question of whether does the end justify the means. And what does this mean in real term is that here the court would be engaged in a balancing exercise where they will have to balance the benefits that stand to be derived if the expropriation is to proceed against the adverse impact that the expropriation action would actually result into if it eventually succeed. So it is just the question of balancing the conflicting interests that are immediately involved whenever the question of expropriation is involved. The benefits, do they outweigh the adverse impact? If they do, then the proportionality leg is satisfied, and the court can give the expropriating authority a go-ahead with the expropriation action. So this is how currently in our jurisprudence the legitimacy of expropriation as a deprivation is gauged or established. And now what happens if a particular expropriation action does not really meet the legitimacy test? Then that would mean that such expropriation is arbitrary. And we know that our constitution does prohibits arbitrary deprivation of property in very strict and strong terms. And now how do we gauge the arbitrariness of such decision to expropriate? Again, the test here for arbitrariness also takes the form of two legs. On the one hand, we have the substantive arbitrariness, and on the other, we have procedural arbitrariness. As for substantive arbitrariness, here, the court that would be approached to determine whether a particular expropriation action is arbitrary or not, the first thing that such particular court will have to do will be to establish whether the arbitrariness is substantive. And what would it look like when such arbitrariness is substantive? There will be lack of sufficient reason, and there will be poor justification of such expropriation. So, like I said earlier, by virtue of it being an administrative decision, the power to expropriate being an administrative decision, it has to follow the PAJA framework that basically explains why the key tenets of public decision making or law making, there must be sufficient reason to explain whatever the decision that the state authority has taken, and there must be proper justification for that. If there are lack of sufficient reasons, if there's poor justification, then of course the court is more likely to arrive at a conclusion that such expropriation is arbitrary, at least in substantive sense. And then we tap again on the procedural arbitrariness. And here it's all about procedure. We have also the case of Mkontwana, where the Constitutional Court gets to actually deal with what procedural arbitrariness exactly mean in the context of Section 25, 1 and 2. And what the court seemed to be aligning itself with the view that says that procedural arbitrariness is as seen within the broader, a much more wider scope of procedural fairness as developed in administrative law. So here, although the expropriation decision would ordinarily be residing within Section 25, and of course the Enabling Expropriation Act, but then to determine the procedural fairness of that decision, the court will have to step out of Section 25 and the PAJA, Section 25 and the Expropriation Act, and step into the PAJA to determine whether such arbitrariness whether such expropriation was procedurally fair. And if the test is positive, then of course the court is unlikely to rule or approve the decision to go ahead with expropriation. Yeah, so far we know what are the key characteristics of expropriation. How do we know that a particular act of expropriation is legitimate or not? And now it is only fair that we then proceed now to deal with the stages that are involved in the expropriation process. How do we go about? How does the expropriating authority go about executing expropriation? And the first stage here is, of course, the investigation and valuation stage. This is the pre-expropriation stage. And I think I must emphasize here and plead for the select committee's attention here that this is particularly important because in the current Expropriation Act that we are having at the moment, there's no provision for pre-expropriation stage. There's no investigation and valuation stage. So this is a new occurrence that the bill stands to contribute towards our legal framework around expropriation. So it must be viewed as a welcome occurrence. And I would be just trying to glimpse all over these 5 stages. There's the subsequent 5 slides, each explains what goes into each of these stages. But for the sake of time, I'll just quickly browse this And I would assume that you have just already engaged with the slides, and you'll be able to just ask me questions on each of the stages if maybe you feel like there's some technical issue that you might need some further clarity on. But like the message that I really want to convey with this expropriation process as contained in the bill is that I'm very much certain that the expropriation bill and the process that it provides for are very much geared towards achieving fairness, which is a very critical barometer for a legitimate practice of expropriation. So the investigation and valuation process, like I said, it precedes the actual expropriation in a sense that here the expropriating authority must ascertain different things, quite a number of things. One of those is the suitability of the property for the intended objectives, and must also ascertain themselves of any unregistered rights that exist in respect of a particular property, and the impact of those rights on the intended use of the expropriated property. So those are some of the ascertainments that the expropriating authority must ascertain in advance before he can actually proceed with the serving of notice of intention. And it is also at this stage the investigation and valuation where the expropriating authority may also conduct consultations with the municipality, and correspondence in that regard may be made with the municipal manager, the municipality within which the expropriated property is located. And the idea here is simply like to find out from the municipal manager, how is this intended expropriation of this particular property going to affect your municipal planning? And the municipal manager will obviously advise the expropriating authority to say, okay, no, the municipality had this kind of planning for that particular property, but if none whatsoever, then the expropriating authority is safe to proceed. And the second stage is now the serving of notice of intention to expropriate. Now, once the investigation and valuation stage is done, the next step for the expropriating authority is to serve the notice of intention to expropriate on the owner of the property or any other person who has a claimable right over the property that is targeted for expropriation. And here, what the notice of intention to expropriate must include certain things, such as, the statement of notice of intention to expropriate. That is basically to say why the notice is there. And of course, after serving like the notice on the owner and any other person who has a right, such notice must be made public. It must be publicized so that the public and interested parties can actually get to lodge whatever comments, objections, and submissions they may have. So so the notice of intention to expropriate must contain, like I said, the statement of notice of intention to expropriate, basically the purpose of the notice. Why am I reading this notice? And it must also have a full description of the property that is targeted for expropriation. It must have the reasons for such expropriation, the intended use of that property after it is successfully expropriated, the estimated date, and if possible, time within which the vesting of rights will actually get to happen, and other things such as the locality of the property, any other thing, permanent attachments to that particular property, any other information that may be of relevance to a particular scenario. And once that is done successfully, The third stage of the process entails the notice of expropriation. And this is where now the real expropriation take place. This is where the actual taking of the property happens. And the expropriating authority must serve this notice again on the owner of the property targeted, or any other person who has a claimable or enforceable right in respect of that targeted property. And of course, the notice of expropriation, just like that of intention to expropriate, must also be made public for interested parties to make known, if any, their comments, submissions, and objections against that intended action. What does the notice of intention, notice of expropriation include? It includes there's a strong commonality between this notice of expropriation and that of notice of intention to expropriate. But here, the notice of expropriation must include details such as the description of the property, obviously, the suitability of that property to achieve the intended objectives that the expropriating authority has in mind, and also the date, importantly, the date in which the expropriating authority will actually be coming to claim the right of possession over that expropriated authority, which is very critical, because the owner or any person who's in charge of the property must be aware of when exactly the expropriating authority will be claiming possession over that respective property. And of course, the fourth stage is the verification of any unregistered rights on property. This is another very critical fairness safety net that the bill provides, because here what the logic behind this stage is basically to invite those uncompensated unregistered rights holders to come forth and submit their claims against the expropriating authority for a possible compensation. And if their claim actually succeeds, that's when now they can start engaging in a process of negotiating, if the expropriating authority is amenable to such, the negotiation of compensation. And if all goes well, having submitted, of course, evidence that goes to prove the existence of their unregistered rights on the targeted property, then of course compensation follows, as if they were known at the beginning of the process. And the last stage, of course, is the determination of compensation. And of course, what we know in our current system is that one of the factors that we consider when we determine the value of compensation that is payable under certain circumstances is, of course, we consider the current use of the property and how does that the economic potential of that particular property, and other relevant factors as may be valued or surveyed by the people with the necessary expertise and speciality, of which the minister is again, or the expropriating authority is again empowered to solicit the service of those kind of professions to come and actually assist with the valuing of the land, the surveying of the land, and all those kind of stuff. So, like I said, that is in a nutshell the process, how it goes. But I'm happy to actually tap into finer details in respect of each stage. If members of the committee may be of interest to a particular stage of the process, I'll be happy to take questions and to actually drill deep on any of the technicality that members might be having. Thank you so much.
Thank you. Let's go back to Professor Mostert.
Yes, colleagues, this is more or less the end of our presentation for you. I have a couple of concluding questions to the committee, but I'm sure maybe the committee would also have questions. So here are some of the things I think one should be thinking about. How does political affiliation or conviction influence the understanding of expropriation? How does the civil service or the bureaucracy view expropriation? What do you think is important for the public at large in respect of expropriation? And how do you think affected owners view the expropriation? But I'll leave it to you to give us questions. If you want to, we also can recommend further reading, and we can make available a reading pack if you would wish that. But for now, we say thank you.
Thank you, Prof, for the comprehensive presentation that we have outlined with your team. I believe it came in handy in view of the next meeting that we are going to have. I will then invite members for any clarity-seeking questions. I've noted three hands. It will be Honorable Dango, and then Honorable Mokheti, and then Honorable Alan Fuchs. Is it Fox? Okay, let's go in that way. And then it will be Honorable Apleni. Let's go in that fashion. Honorable Dango.
Chairperson, thank you very much. I want to put a practical issue before the presenters. First, I want to thank them for their presentation. I take the practical issue of the land in Salt River, where there's a club on, and the land is intended now to be developed into a very major industrial and shopping center for Amazon. But the land that is intended to be built upon, culturally, the Khoisan people have always been connected to that piece of land, and it was taken away from them at the time when there was no individual land register. It was collective land. If they want to actually now claim that land back without compensation for their cultural purposes and possibly for development purposes, how would they go about that? Because they were dispossessed of land. The land was not, there was no land registered at the time of dispossession. They now, and have historically had a cultural link to there, and now want to actually claim that back. How would they go about doing that for them? Because I think this is the history of South Africa. And I think the history that is going to be very difficult, that we're going to have to deal with, and sensitive, because we need to deal with the sensitivities of people who had been dispossessed in the past. Thank you.
Thank you, Honorable Dango. Dr. Mokheti.
Would you like us to take? Would you like us to take all the questions first, or do them one by one?
Let's take all the questions, Prof. Let's take all the questions. Yes, Dr. Mokheti.
Thank you very much, Honorable Chair. I don't see if my camera is on or what, but I would request to switch it off for a better connection, because where I am, I've got load shedding now. If you allow, Chair.
Yes, no problem with that.
Thank you very much, Chair. Let me first take this opportunity to thank Prof and all other presenters. Chair, I think it is an eye-opener for all of us. And my question for clarity, Chair, would relate to what Mr. Matiba has said with regard to expropriation against the owner's will. We are faced with a challenge of shack farming in Gauteng and in the country, where you find that the owner of the land is either in Netherlands or US or any other country. But you find that that land, there are shacks that are mushrooming and it is well coordinated. You can see that this is a well orchestrated type of invasion of land. So where we find, sometimes we find that they invade prime land. When you go along the N12, you see that there are shacks on the mountain. And for me, I view that as prime land that can be used for proper housing, where at least the municipality can generate income and also use it maybe for their own use. And in some instances, you find that there are people who are coordinating this. You find that they also connect electricity. They somehow illegally connect water. And in some instances, along the N12 to Joburg, again, there is the shacks that are mushrooming there, and they are in a very unsafe land. And when there are floods, you might find that the whole shacks can be like taken by water. So in that case, how does the bill assist government to expropriate land where someone is sitting somewhere overseas? And then I heard Mr. Matiba also saying that we can serve a notice for someone that maybe maybe the land that you want. You can serve a notice and give reasons why you have to expropriate. So how do we expropriate land of somebody that you cannot find anywhere in the country, and find that in some instances there are few people who knows the whereabouts of that person? So how does the bill assist us to expropriate in such cases? Thank you very much, Chair.
Thank you. Honorable Fa-
Chair, thank you very much. Alan Fuchs from Gauteng. I'm really interested to hear from Mr. Matiba the legal arguments around the question of fairness. In the event that a property has improvements and there's also a bond on that property, under what circumstances would it be argued to be fair that that property be expropriated, taking into account the fact that the bondholder in this case would no longer be able to utilize that property, and they would still be liable to pay the bond to the bank? Thank you, Chair.
Thank you, Mr. Fox. Honorable Apleni.
Thank you very much, Chairman. Let me first thank the team for the clear presentation. Now, Chairperson, let me first start by saying openly and without any fear that I'm not shocked to hear the comments that suggested that it would be better to expropriate land from the people who are occupying land. We have no houses, we have nowhere to go, we have seen the open land that is not being used, and make a use of that so that they can be able to live with their families. So it is not shocking to find some taking that posture of seeing the land that is being occupied by those people as the land that should be expropriated, instead of the land which was stolen by the land thieves, which should be expropriated in actual fact without compensation.
But the question that I have, Chairperson, it is clear that from the presentation that expropriation is possible. But the question that I have is that what is hindering our government from expropriating our government and the municipalities, expropriating land for development? Because we have places where schools cannot be built, where the government wants to expand the roads or build new roads that they can't. And in most cases, you would find out that even the people who are actually occupying such land in which it is difficult for our government to develop, that majority of those people don't even have the title deeds for the land that they are occupying. So what is it that is stopping our government from doing so? Is it so difficult for the government to expropriate the land in which some of the occupants of that land do not even have title deeds? Thank you very much, Chairperson.
Thank you, Honorable Pleni. Honorable Chabalala.
My apology, Honorable Chair. I'm just struggling with the network. Let me also take this opportunity, Chair. It's Honorable Chabalala from the Free State. It was just an unfortunate. I want to appreciate the presentations. I think it's this problem of load shedding where I was unable to hear very clearly. But taking a cue from what has been presented, I wanted just to ask in terms of the municipal tribunals. I think in the first presentation, it was a little bit of touched. And just to see, Chair, on how the section talks to the level of municipalities at that level of municipal tribunals on how these tribunals would be assisted in this matter of expropriating land. So I just wanted to hear if there is any framework that would be able to assist, because if you look at now, Chairperson, most of the municipal tribunals, some you have people who did not, who do not qualify in terms of the requirements and how that would also assist in terms of correcting that. So that is just the clarity I wanted to ask. Generally, would appreciate if we could also have these presentations so that we are able to make follow-ups to the relevant stakeholders that we're doing a presentation. And thank you very much, Chair.
Thank you, Honorable Chabalala. Honorable Bratiseth.
Thank you, Chairperson. Chairperson, I am still struggling with signal. So if you can hear me, and I do apologize for any background noise, I hope you can hear me okay, Chairperson. I have a number of high-level questions. So if
I wonder.
The panel can just, are you able to hear me?
Struggling to hear.
Are you struggling to hear?
Are they struggling to hear me?
Yes, this works.
Chairperson, is that better?
Yes, we can hear you. But it looks like the team that side is struggling. But we can
Chairperson, is that better?
Yes.
No,
that's better.
we're struggling to hear now.
Right, Chairperson. Chairperson, first of all, I'd like to just thank the panel for their presentation. It's extremely interesting. I'm sure to yourself as a person with a legal background, it's been very interesting. My first question is, the bill specifically says that property can be expropriated for public purpose and public interest. So my first question to the panel is, who determines public purpose and who determines public interest? That's the first question. The second question, perhaps to Dr. Kramer specifically, is why is the bill so wide in terms of property definition? And why would the expropriating authority want to expropriate intangible assets, movable assets, intellectual property, etc.?
Because the preamble to the bill is section 25, and the entire, one of the biggest motivations for the bill is land reform, which we have no problem with. But why then expand it out to being able to expropriate a person's business, expropriate their piece of art, expropriate a book that they've made written, expropriate, try and repurpose a business for another decision. So the question really is why on earth would the expropriation laws be so wide? And I love Dr. Kramer's interpretation is that referring a question from one parent to another. And so the question also allied linked to that is, if it is so wide, is it constitutional? Will it pass constitutional muster? Then the other question is now you have Mr. X or Mrs. X owning a piece of property. Government comes along and says, we want to expropriate. They go through all the steps that Mr. Matiba set out, but what protection do they have to defend that in court? Because defending it in court places a massive onus on the property owner to actually defend that in court. And in most cases, Chair, they simply would not have the resources to do so. So what level of protection does exist for the property owner now to defend this in court and prove that the decision was not rational, prove the decision was not proportional? And then my final question is, maybe to Mr. Matiba, is could you please go through that determination of compensation stage? Because that section 12C creates great uncertainty, especially in line with the entire idea that property may be expropriated with no compensation. And so if we could just get a much larger explanation of the determination of compensation and what factors are at play there. Thank you very much, Chair. I'm sorry for the background noise and my lack of signal. Thank you so much.
Thank you, Tim. Just the one question from my side. The current Expropriation Act, which was correctly pointed out that it is 20 years older than the Constitution. The question that I want to pose is: has there been enough litigation on the matter on cases on this on expropriation on this old regime, and if it is not enough, could the reason be attributed to the fact that the current regime does not make provision for the for section 25? It did not. It came before that. And then one of the issues that you raised was that you raised the issue around the influence. I mean, among those issues that you raised relates to the two extremes, the big state and the small state, which obviously I think is more ideological. Which Professor Monsteret has indicated that it could play a role in terms of your appreciation and comprehension of expropriation. But given the fact that our state is constitutional, it's not. We are following constitutional democracy instead of parliamentary democracy, which is practiced in other countries like the UK. Do you think that that those extremes are relevant, given the fact that as a constitutional state, first and foremost, whatever you do in terms of as a state, in terms of administrative action, it must be preceded by the values that are enshrined in the Constitution, which amongst them include the issues of rationality and transparency that we have referred to. But more than that, the supremacy of the Constitution, meaning that if a local government or a department takes a decision that is irrational, where there is no connection between the decision that you take and the facts before you, definitely the probabilities of that decision being set aside by a court of law, it's guaranteed, because you would not have you would have acted irrational, and having acted irrational and not in a transparent way, you would have definitely undermined the Constitution. You would have undermined the rule of law. Therefore, the question is it still necessary as a starting point to factor those two extremes, or let alone conceptual understanding of a state or a classless society, which obviously, like as you said, the reality of the matter is from those that comes from the big state, they move. The point of departure is the base, is the economic base, and the issue is that the base will always influence the superstructure, meaning that the dominant class in the mode of production will influence the type of politics or or state that prevails. Hence, I'm saying that is it really necessary to go to that, given the fact that the framework of our state is enshrined in the Constitution. Thank you. You can take the floor, Prof.
Let me see. Can you hear me?
Yes, we can hear you, Prof.
Thank you very much, colleagues, for all of the questions. Perhaps you'll allow me to moderate just that we can decide who answers what. I'm going to start with the first question, which was about our community in Salt River and their ability to have the land expropriated for development purposes, but also for cultural purposes. I'm very glad that the question came up, because preparing our presentation to you, we were wondering in how much depth we should go in. And one of the topics that landed on the cutting floor was the possibility of expropriating for third parties. So I am going to ask Mr. Matiba to say a few words about that, but just to say that the system, the process does envisage the possibility of expropriation for restitution purposes, which it sounds to me as if this community would qualify for that. And it also enables, the system also enables the possibility of the state expropriating for the benefit of a third party, such as a community that receives, that should receive their land back because of restitution. It even provides the possibility of expropriation for the benefit of a developer. And we have some examples in that regard as well, but I'm not going to say anything now because there's another question that deals with that, but I'll just hand over to Mr. Matiba to say something about the community rights.
Yes, thank you so much, members of the committee, for the questions. Yes, indeed. Prof. Mostert has actually said mostly, just very briefly about third-party transfers, which I think the question by the first member of the committee relates to. I think I should just add maybe on that to say that the bill actually does empower the expropriating authority to expropriate property for third-party transfers, and that is in cases where maybe there's economic development adventures that such third party presents to the expropriating authority. And of course, that community, if it is having the rights on that property on the basis, if their rights are claimable or enforceable in the basis of IPILRA, that is the interim protection of informal land rights, they also have kind of a safety net in that statute to actually enforce their rights on land. And but yeah, for restitutionary purposes, the bill is very much clear on that. Yeah, and then I thought I should just add on that insofar as the third-party transfers is concerned. I'll give back to Prof. Mostert to just finish with the questions, and then I'll proceed later with other questions that were directed to me. Thank you.
Yes. So thank you, Matiba. Our next question was about expropriation against the owner's will where the owner cannot be found. We have to deliberate that a bit. My sense of that is there is a formal way of finding the owner, in that the landowner will have a registered domicilium address in the land register. So even if the owner cannot physically be found, there is a place where the owner can legally be found and where the expropriation notice can be served. Am I correct?
Yes, that is very correct, Prof. And members of the committee might actually have heard that in some part of the process of expropriation, the verification and the investigation, which is the pre-expropriation process, one of the entities that the expropriating authority must actually consult with is the DIS office. And of course, the DIS office will be in a much better position to actually provide the most updated details of that owner, even if he is currently abroad and not within the borders of the Republic. So the domicilium that will be registered at the DIS office, that is where the notice of intention, or let alone the notice to expropriate, may actually get to be served on that owner. Otherwise, but this is the extreme now scenario, the expropriating authority may resort to actually institute eviction proceedings in terms of Section 6 of the PI, that is the Prevention of Illegal Evictions Act, to actually get to evict those unlawful occupants from the land that is targeted for expropriation. The state is very much, clothed with the necessary powers to institute those kind of proceedings. And I would assume that if the owner is not around and there are a lot of mushrooming squatter camps in the land that belongs to that particular owner, then the state has a valid leg to stand on and invoke Section 26 of the PI to actually effect evictions of those people.
Thank you. And then there's also the element to that question, which I think is very interesting and which should be raised, is the underlying concern. It struck me as being that informality is taking over on vast tracts of our land. Informal settlements are emerging. The word mushrooming used. And I think that is a very valid concern. What happens with informality, when informality takes over, the state loses its power. And we're returning back to, if you can remember the slide that we had in the beginning, with the two pies on them. Where is that now? We're returning to what Epstein would call a state of nature, where everybody is fending for themselves and everybody is protecting their own rights, and there is no mention-worthy state to think of. And it's a matter of great concern where informality is taking over in a system where there is supposed to be a state which can protect and which can regulate. So that is an important question, and I think for the committee members specifically thinking about the role of the state and the responsibility of the state also in that context. The next question was about the arguments around the question of fairness, and specifically the way in which bondholders and other right holders are affected when property is expropriated. Now, Mr. Matiba had a specific slide prepared for that. I'm sure he would love to show that. So I'm just going to hand over to him again.
Yes, thanks, Honorable Member, for that question on the fairness as it relates to the mortgage bond holders in the event whereby the mortgaged property is subject for expropriation. I think there's somewhere, I think it is in one of the slides where I didn't go much into detail, where there's actually, yeah, here is the slide. So I did say here in the procedural arbitrariness part that the main barometer here that claims in the legitimacy or assessing whether the extent of arbitrariness of a particular expropriation act is how fair was that decision, or how fair is the process, was the process that led to that decision being taken. But I wish to reiterate this point and say to you that the bill actually anticipates that the land or the property that is mortgaged might actually be the target for expropriation. And for that regard, it acknowledges that the bondholders or the bond owners or someone who has the bond registered on their name in respect of the targeted property must also be served with the notice. And when you look closer again at chapter 5 of the bill, it's all about compensation. It explains all the technicalities around the compensation for expropriation. And I love the wording of the bill here, because it says that the amount of compensation to be paid to an expropriated owner or holder must be just and equitable, reflecting an equitable balance between the public interest and the interest of the expropriated owner or expropriated holder. In this case, who might be someone who is currently servicing the bond in respect of a piece of land that is now going to be taken away by the state. So here, the whole notion is simply to say that the bill is mindful that both interests must be considered. And I said that when it is the role of the court, if maybe the aggrieved party may want to actually, litigate this, challenge the decision to expropriate and bring that challenge before the court, it will be the question before the court to actually determine the question, does the end justify the means? And if the court answers that question not in the affirmative, then it means that the rights or the interest of the mortgage holder will then be respected, or will then be retained in that way. Because then what the court would then arrive at, what would be the order of the court would then reach the decision to say that expropriation under that given circumstances may not hold or may not proceed. So the bill actually does have a very good acknowledgement of the interest of people who might actually be servicing the bonds currently in respect of the land or properties that might be targeted for expropriation.
Thank you very much. Yes, that was a very thorough exposition. Our next question was about the question, I read the question as being basically what is taking the government so long? What is stopping them from expropriating? And specifically for purposes of economic development. I think that is also a very valid question. And I think it ties up with another question that was asked about understanding public purpose and public interest in the context of expropriation. So I'll take a shot at this, and if any of my colleagues want to add, then maybe just give me an indication. Public purpose and public interest is one of the parameters of fairness in the expropriation process, and that is what drives decisions to expropriate. These decisions about what is in the public interest and what is in the what could be a public purpose has been the subject of a lot of investigation. And for the South African context specifically, I undertook an analysis of all of the court cases that considered public purpose and public interest in expropriation matters a while ago. What was very interesting for me to see was that the public interest requirement was introduced by the Constitution. In the Expropriation Act, this fairness requirement is articulated as a public purpose requirement. And the Expropriation Act, written 20 years ago, before we had land reform, before we had restitution, before we had a constitution, was very much focused on what I would refer to as standard bread and butter kind of expropriations, to build a road, to build a hospital, that kind of thing. Introducing public interest through the Constitution was specifically also geared towards opening up the expropriation process to enable transformation. What was very interesting looking at the court cases, though, was that all the transformative issues, restitution, land reform, housing, eviction, all of those questions where they bump up against expropriation questions, the court used not the public interest standard, but the public purpose standard to resolve the matter. And very interestingly, in newer cases around expropriation for economic development, expropriation for third parties, or change of the purpose of expropriation, the court used the public interest parameter to evaluate the situation. That is a strange anomaly, and that is what we are sitting with at the moment. But the good news is our public purpose, public interest parameter is wide enough to encompass both the standard economic based expropriations as well as transformation driven expropriations. So I think in terms of the law, nothing is standing in the way of getting the government to introduce a model of economic development that would benefit all of the people of South Africa. I also want to add that the government governs not only the people that voted it into power, but all of the people in its particular realm. And the fairness requirement that was asked about very much has to take that into account. It's not only about the people who voted for the government, but being fair to everybody in the jurisdiction. Would you like to add something? Are you then, because our next question is about the municipal tribunals and how municipalities and municipal tribunals can be assisted to expropriate. And here the conversation is probably also again with Matiba. My sense is that the Constitution, if we look at all the acts, that we have identified where expropriation, the power to expropriate has been made available, all of those many slides that we put together, it's almost like a family of statutes that permit expropriation. And at the head of this family stands a mother and a father. The father is the Constitution, and the mother at the moment is the Expropriation Act. What we are trying to do is to replace the mother with a new one, a new mother who is going to run the family in a slightly different way. The new the expropriation bill, which will become the new Expropriation Act in due course, has a particular way of arranging and organizing the family. Many of the systems will remain in place and will remain the same. But this bill is the beginning of a new framework for expropriation and a new framework for governing in the realm of the eminent domain. And I think that is important to keep in mind. It also takes us to the next question, which was directed at Richard. Where is Richard? Which is, why is the bill so wide, especially as far as the property definition is concerned? Why is it necessary to think about intangible assets?
Well, the bill itself is not just about expropriating land, even if the main impetus for passing a new bill is to facilitate land reform. It's an expropriation bill in general, just the way, in the same way the Act of 1975 that it would replace was an expropriation bill act in general, which itself provided for the expropriation of land and other property. So ultimately, the reason the definition of property is wide in the expropriation bill is because the definition of property in the Constitution is wide. And the Constitution itself makes provision for the expropriation of property, not just land. So the bill itself has to give effect to the Constitution's provisions regarding expropriation, because the bill permits the expropriation of any property, and property is not limited to land. And it's actually, in a way, it's good for holders of right that the definition of property is so wide, because if these rights are taken from you by the state must compensate you. And because we have such a wide umbrella, it's providing more protection for holders of economically valuable rights that might not have been protected before the Constitution. If the state takes these rights and takes the substance of these rights, the state must compensate. But at the same time, it needs to be done for a public purpose or in the public interest. And obviously that's a much easier requirement to meet in respect of land. And it is obviously a bit more difficult to think of examples where you could expropriate non-property other than land for a public purpose. Obviously, there might be a case we want to nationalize certain companies and take those shares, potentially for a public purpose. Or maybe when we're dealing with intellectual property, a patent in certain medicine might be expropriated for a public purpose. But it's very unlikely that the public purpose requirement could ever be met for the state taking your copyright in a book you wrote. So again, it's wide because the definition in the Constitution is wide, and the Constitution allows the expropriation of anything considered constitutional property. But again, when you move away from land, the public purpose, public interest requirement really operates as a brake on what rights the state can just expropriate.
Thank you. Thanks. I would probably add,
Prof,
yes.
My apology. Are you going, because we're supposed to be receiving the presentation from the department now.
Yes. There are
Are
a
you going
couple
to,
of unanswered.
I just want to check something. Are you going to remain? Because I suspect some of the questions could be answered by the department. So
Yes, I think there are about 5 unanswered questions here.
Yes.
I don't think we are invited to the next part of the meeting. I think that part is closed, but we are more than happy to return and have another conversation with you about and we are also very happy to take questions in the meantime around which we can prepare answers for you.
Yeah, but even responding to them in writing and then sending them to either Dr. Anik or the committee secretary will quite appreciate that. But if you will be with us, we'll quite appreciate that. It is committee meetings are open to the public. So if you have time, you can remain in the meeting, and then we invite the department to present, and probably some of the questions they will be able to respond to them. But we'll appreciate it if you can even send those the responses in writing. If that is comfortable.
We can do our best to do so. It might take a little bit longer to receive it in writing, but we'll try. Thank you very much, colleagues, again, for giving us an opportunity to engage with you. I'm sorry that we couldn't get to all the very, very good questions. It gives us more reason to do this research and to continue working on it. Thank you very much.
Thank you, Doc. Professor, Tim?
Chairperson, I'm sorry to do this, but my two questions that were very important were about to be answered. I understand if they can be answered in writing, but if I can just please, it's extremely important, Chairperson. The second to last question, I did ask about the constitutionality, but I'm sure that the professor, the doctor, and Mr. Matiba can comment on that. But the most important thing is the landowner, or the owner of the property, that now has to go to court and incur massive costs to defend their possession. What protection is there for them in that regard, if there is any? And then the other question I'd just like the panel to consider, and please respond in writing, and obviously if they can respond as soon as possible, is are there any examples of in the past expropriation, since the passing of this act originally in 1975, I think, of expropriation of intangible assets? In other words, intellectual property, businesses, etc., etc. Are there any examples of that, and how were they dealt? Maybe they include that in their research. The Chair, I'm very concerned about the onus placed on the simple, maybe not well-resourced landowner that is bonded up to the hilt, who does not have the hundreds of thousands and maybe the millions to go to court and defend against a department who has all the resources in the world. That's a very important question, Chairperson. Thank you.
Thank you, Tim, for your indulgence. Committee Secretary, can you put the Part B agenda on the screen?
Yes, Chair, I'm doing so.
Thank you. Thank you, colleagues. Again, just before Part 2, just a word of gratitude to the professor and her team for the brilliant work that was done in terms of laying the conceptual framework for us to understand where the concept expropriation comes from, where to locate it within the broader process of private property, public property. What are the how did it evolve? What are the processes that has to be involved in terms and stages that has to be involved before you expropriate? What is it that can be expropriated? Who can be expropriated? You helped us a great deal for that. And again, on behalf of the Select Committee, a sincere word of gratitude to your effort in honoring our invite. Thank you a lot, Prof. Members, we will now move to the second leg, which is the briefing on the expropriation bill by the Department of Public Works. We understand that the Minister has joined us. Greetings to you, Minister. Indeed, we welcome you to this meeting. And we will invite you to take the platform, because we have already welcomed other members of the team from provinces and members of the Select Committee. The floor is yours, Minister.
Thank you, Chairperson.
And compliment of the new season to you.
Yes, thank you, Chairperson. Chairperson, I will first of all ask permission to put off my video. As you can see, the screen is not very good. So thank you for that. Chairperson, I am joined today by 6 officials from my department and also by Advocate Uday Naidu, that has been working with the committee since the inception of the bill. Chairperson, I would just like to make 3 introductory remarks before I ask Advocate Naidu to come in and do our presentation. And I want to deal first of all with the historical context of the bill, why the bill is needed. And lastly, I would like to share with the standing committee a current case study for expropriation for the public good, public purpose, or public interest, whatever we want to call it. My first point, Honorable Chairperson and members, is that expropriation is not unique to South Africa. The abilities of governments to acquire or expropriate land for the public good, it is something found worldwide. We have presented this bill as part of our consultation, Honorable Members and Chair, also to all the ambassadors and high commissioners based in South Africa. This power of governments, of a local government, provincial government, national government, to take property for public use exists, for example, in the United States of America, the UK, New Zealand, Australia, South Korea, and Africa. We're talking about Ethiopia, Rwanda, Brazil, and many other countries. And our constitution expressly authorizes expropriation to redress the injustices of the past. So these powers of expropriation is called different names in different countries. In the United States of America, they use the term called eminent domain. India and Singapore, it's referred to as land acquisition, because expropriation is another form of acquisition. And also in the UK and New Zealand and Ireland, it's called compulsory purchase. And so you can go on to Canada, Russia, to Brazil. Most of the Western countries, these powers are referred to as expropriation. Now, why the bill is needed? The bill is part of the government's comprehensive approach to land reform and redressing spatial inequality and improving access to services and opportunities. So the government is committed to restitution, to redistribution and land tenure, as was recommended by the Presidential Advisory Panel in 2019. We also see, Honorable Chairperson, that this bill will bring certainty to South Africans and investors, because it clearly outlines how expropriation can be done and on what basis. So this legislative certainty is critical as we rebuild our economy and we invest in our community. The existing Expropriation Act dates back to 1975. The Presidential Advisory Panel pointed out that this 1975 Act is inconsistent with the Constitution, and the correction of this has been long delayed. The panel also pointed out that the 1975 Act undermines the constitutionally enshrined principles of lawful, procedural, fair, and a reasonable administrative justice.
So that is why the bill is needed. But one of the cornerstones of this proposed legislation is that the holders of unregistered rights in property must be treated on an equal and procedurally fair basis in the expropriation of such property. Also, and I'm making this point deliberately because of the fear mongering in our country about expropriation. All South Africans are equally protected in the Bill of Rights in Chapter 2 under Section 38 of the Bill of Rights. So I want to share with you quickly, Chairperson, just to illustrate using the existing 1975 Act that the Department of Public Works and Infrastructure, we're being requested by ESCOM to expropriate servitudes in terms of the existing legislation for electricity transmission lines on its behalf to allow the entity to supply more power to areas in Limpopo than what is currently possible. ESCOM needs to strengthen their electricity network by upgrading the existing substations to increase the capacity of power transmission. And this will also allow ESCOM to provide more electricity in Limpopo for the public interest, the public good, and the public purpose. So we have been using and helping ESCOM with the expropriation of the servitudes. It was done in terms of Section 3 of the Act 63 of 1975, but read together with the Regulation Act 4 of 2006, the electricity regulations for expropriation on behalf of a licensee. Now, what did we experience here, Chairperson? That the design and the route of the required power lines crosses over state-owned property and privately owned land. So some privately owned land is affected by the design of the new power lines. And ESCOM has stated that the servitudes and the new power lines do not impose detrimental effects in respect of these properties, which cannot be addressed by a reasonable compensation to private owners, and ESCOM is willing to pay. So what happened is that the property owners who did not enter into servitudes agreements were notified by the state's intention to expropriate in terms of the 1975 Act. And they've been served with the necessary expropriation notices. The property owners were informed in the expropriation notices that the date of expropriation is the 31st of January 2023, and that expropriated rights will be exercised by ESCOM on the 1st of February. We are currently in the 60 days process whereby if the owners have received this expropriation notices, they must revert to the Minister of Public Works and Infrastructure with the required information, the amount claimed by the owner as compensation, and how much of that amount represents the amount contemplated in Section 12(1)(b) of the 1975 Act, and other details that is necessary. This illustrates, Chairperson and honorable members, that the energy crisis requires all of us to work together for the greater good of our country, such as ensuring that the provision of the necessary infrastructure to enhance electricity supply is met. And I can present, if members are interested, exactly the process that we have followed in terms of 1975 Act. I also want to wish the committee well, Honorable Chairperson, with all your consultations. I know that you're consulting wide, and we have presented this bill to the National Assembly, and it was passed by the National Assembly, but we said... yes.
Thank you, Minister.
Thank you, Chairperson, and honourable members of the committee. Thank you, Minister and members of the department for inviting me here. I'm very grateful for the opportunity. I had submitted to the department a few weeks ago a memorandum for presentation to the NCOP Select Committee dealing with the bill, an overview of the bill, and some select topics for discussion and consideration. I trust that the committee has had an opportunity to read that document, and the committee may well have recognized some themes that our esteemed academics picked up on during their discussions. I don't intend to repeat much of what they've said. The purpose of this discussion is to give the committee an overview of the bill, the process of the bill, and some of the key variables under the bill. I do, however, think, based on the questions that members have asked, that it would be worthwhile spending some time dealing with those points towards the second half of my presentation today. I think that particular topics that require further discussion would be the definition of property, the application of the bill to transfers to third parties, the definition of public purpose and public interest as the substantive justifications for an expropriation, and the difficult position that mortgagees might find themselves in, and the remedies that the bill provides for them. These are very important practical issues that I would like to touch on during the course of my oral presentation. To start, we've already been told that this bill is intended to be enacted pursuant.
My apology, Advocate Najim. Maybe if Enrico or Klipeka can just share that memo on the screen, so that at least as you speak, members must be able to see what we are talking to. Enrico, can you share that memo?
Thank you, Chair. We have given Advocate Naidu the presenting rights. He can share on his part.
Oh, I see. Chairperson, I find that because this is rather a long document, all in black and white, it's not very animated, it might be better for me simply to speak to the committee about the issues and let them read the document in their own time, if that's all right with you.
No, that's fine. I'll get guidance from the members where they need intervention. Thank you.
All right.
Proceed.
So this bill is really designed, as the presenters have explained, to be enacted pursuant to Section 25. Old order legislation, which has to be in a way to best fit Section 25 of the Constitution, is to design a bill which fits seamlessly with Section 25. This is an important theme, the symmetry between Section 25 and the bill. This has implications for the way in which property has been defined and the way in which public purpose and public interest have been defined. Let me go directly to that question. Property in the bill is defined as property in terms of Section 25 of the Constitution. One of the doctor earlier on likened it to a circular definition, and indeed it is circular. but there's a purpose behind that. It was done deliberately because the Constitutional Court has warned time and time again that it would be inadvisable to define property in a way that stonewalls it. From the time the Constitutional Court has been established to now, it has constantly expanded on the meaning of constitutional property. And so the idea behind defining property in the bill, as it has been, is to ensure that as the courts develop the notion of constitutional property, the bill always keeps track of that concept. There will be no asymmetry between property under the bill and property under Section 25 of the Constitution. Now, of course, as the doctor said, that doesn't necessarily mean that all property is up for grabs, because there are conditions on the exercise of the power to expropriate property. The primary consideration, the substantive justification for taking property from a private individual is that it must be used for public purpose or in the public interest. That's the first point. So that constrains, narrows down which kinds of property are going to be considered for expropriation. The second consideration, which the doctor mentioned, is that the property must be capable of state acquisition. The state must itself be able to take the property. And of course, if the state created the property itself, for example, a permit, taking the property for use by the state would be a misnomer. And so property that cannot be acquired for state use for public purpose or in the public interest would also fall outside the set of property that is reasonably contemplated under the expropriation bill. Of course, we know what the purpose of the bill is. It's not just to acquire property for public purpose, to use for the public benefit or by the public. Another important purpose is also land reform. This is a pressing need and a constitutionally required measure for the state to undertake to bring about redress of past injustice, particularly proprietary injustice. What the bill intends to do is to facilitate the transfer of private property to particular individuals for land reform purposes, to bring about equitable access to the nation's resources. That is something mandated in Section 25 of the Constitution itself. These types of transfers are different from expropriations generally in that the property is not acquired by the state, one, and two, the property won't be used by the public generally. It will be for the benefit of a particular individual for a constitutionally authorized purpose, land reform. In the bill, when it was before the Portfolio Committee in the NA, we had raised a drafting issue with the application of the bill insofar as it related to the transfer of property to third parties. Unfortunately, that issue still remains, but it is an issue which this committee can and should deal with. If I could take the committee, please, to the definition of expropriation in the bill. The committee will find it at page 5. This definition comes straight from a judgment of the Constitutional Court in a decision called Agri SA. Expropriation means the compulsory acquisition of property by an expropriating authority. So the state itself must take the property, and what the state acquires must either be the same or substantially similar to the rights that have been taken. The purpose must be for public purpose or in the public interest. Additionally, an organ of state which requests property for a public purpose can ask an expropriating authority to expropriate that property for it, for the organ of state. What the committee will notice is that the definition of expropriation does not contemplate direct transfers to individual third parties. It contemplates only acquisition by the state or an organ of state through an expropriating authority. And that's because that's what the Constitutional Court has defined expropriation to be. So as to give effect to the purpose of land reform, what the department recommended to the Portfolio Committee was to include in the application clause, clause 2 under the bill, a provision which ensured that third-party transfers in the public interest would be governed by the protections and the mechanisms under the bill. The clause that we proposed essentially said that the provisions of this act will apply to transfers of property to a third party in the public interest with the necessary changes required by the context. And so in that way, we wanted to account for the fullness of public interest and public purpose transfers. Unfortunately, the committee did not accept that proposal. I'm not so certain of the reasons why, but it does leave a gap in the statutory framework, which I think this committee needs to address. We have written an opinion on it before, and that may be made available subject to what my principal instructs. Turning back to page 5, what is a public purpose for the purposes of this act? Previously, the concepts of public interest and public purpose were undefined in terms of legislation. Courts interpreted those two variables to mean different things. Sometimes there was consistency and sometimes there wasn't. The honorable member, I think from Gauteng, raised a question about who defines the public purpose and the public interest. Well, happily, the bill seeks to do just that. In a later amendment to the bill, the Portfolio Committee accepted the department's suggestion to define public purpose in the following way. A public purpose includes any purposes connected to the administration of any law by an organ of state, in terms of which the property concerned will be used by or for the benefit of the public. So, to answer the member's question, who determines what is a public purpose? Parliament does, when Parliament enacts legislation. Provincial legislatures can do so when they act provincial legislation. And municipal councils can do so when they pass bylaws dealing with expropriatory matters. So there is a democratic element which comes into play when one defines what a public purpose is. Going back to the definition of a public purpose, the purpose must be set out in an empowering law. Let's take an example. Let's say we're dealing with an Education Act. The power to expropriate will be exercised for the purposes of building a new school or extending the property on which an existing school is so that there can be a boarding house. The minister responsible for administering that particular statute, or the MEC, which is more correctly the case, can use the power to expropriate only for the limited purpose defined in the Education Act, which will be for educational purposes. That would be a public purpose under the Expropriation Bill. In exercising that power, in order to exercise that power consistently with this act, the object needs to be use by the public of that particular property or use in an indirect sense for the public benefit. So let's say this is a public school. If the MEC expropriates the land next door to build a boarding facility, the public, those people who attend the school, will be able to use that land directly once a boarding house has been built. What about indirect purposes? Let's say the Department of Public Works has been asked by the Department of Education to acquire land or building for it so that it can run its offices from the building. It doesn't need to pay exorbitant amounts of rental to a private owner. It instead will have the benefit of publicly owned property. If the minister is satisfied that the Department of Education needs that building for its housing requirements, the minister will be exercising her expropriation powers for a public purpose, namely to provide housing to another government department for it to fulfill its mandate. Now, the public doesn't use that building directly. The building is used by a government agency, but the use of that building by a government agency benefits the public indirectly. All those purposes would have to be defined in legislation itself. The bill creates a substantive power for the minister to expropriate property, but it doesn't exclusively regulate the field. There are other pieces of legislation which the professor identified, which empower other organs of state, members of the executive or functionaries, whatever the case may be, to expropriate property for the purposes as defined in those empowering statutes. So, to answer the question as far as public purpose is concerned, the public purposes will be defined by the lawgivers. Public interest is different. Public interest means something different from public purpose, but it hasn't been exhaustively defined by the courts. What the Constitution says is that the public interest includes the nation's commitment to land reform, reforms to bring about equitable access to natural resources, and to redress the results of past discriminatory laws or practices. That's just part of the public interest. The public interest may go beyond that, but we don't know what the additional content is. The courts haven't yet defined it, and it would be inadvisable for Parliament, in passing this legislation, unnaturally to constrain the meaning of public interest, where constraining the meaning might result in asymmetry with the public interest as envisaged in the Constitution. Remember, I spoke about symmetry when it came to the definition of property? Well, exactly the same thing applies when we think about public interest. What we can say about public interest on an interpretation of the bill itself is that it doesn't include the public purpose. The expropriation of particular property may serve both a public purpose and a public interest, but these two variables mean something different. Public purpose is defined in empowering legislation, which is administered by an organ of state, for expropriating property for use by the public or for a public benefit. Whereas public interest would cover everything else contemplated under the Constitution. May I pause at this point to ask for any questions of clarity, Chair? Because I think it is an important point.
Thank you, Advocate. I just want to check with the honorable members whether they have any other questions to pose to Advocate Naidu. How far are you, Advocate?
I understand that I'm meant to end by 12:15. I would say I need another 10 or 15 minutes, if that's in order.
All right. Why don't we run until you are done, and then we invite questions from after you have done, and then request honorable members to note their questions. The reason why I'm raising this is because 2 o'clock is budget speech, and I suspect members might want to get into the budget speech and probably prepare themselves before that. Yeah, let's ask members to note their questions, and then we can then just finish your presentation and we'll pose questions.
Thank you, Chair. This is a very rich and detailed bill, and there'll be lots of questions, I'm sure. But for present purposes, let me give an overview of some of the, continue with the overview of some of the key points. We've covered third-party transfers, the definition of property, the definition of public purpose, public interest. What I'd like to move on to is what is a topic of concern for many. How is the amount of compensation calculated? Compensation is a particularly important aspect of any decision to expropriate, but it isn't the justification for the expropriation itself. It's a consequence of a decision to expropriate. The decision to expropriate must be taken based primarily on whether the acquisition of the property will serve the public purpose or be in the public interest. Whether the state will decide to expropriate the property will depend on the suitability of the property. One of the considerations in determining whether the property is suitable would be the amount of compensation that would need to be paid for that property. The amount of compensation needs to be just and equitable, and it needs to reflect an equitable balance between the public interest and the interests of those who will be affected by the expropriation, if the expropriation is in fact proceeded with. The bill was revised to reorder the sequencing of events so that instead of determining compensation after the decision to expropriate was taken, the analysis of what the just and equitable compensation would be was brought forward so that it would inform the question of whether to expropriate at all. And the committee accepted this. The issue I would like to flag for the committee's consideration is how Section 12 has been formulated in the bill. The particular part of Section 12, Clause 12.1 that I'd like the committee to focus on is on page 13. Now, if the committee compares Clause 12.1 to Section 25.3 of the Constitution, which is quoted in the preamble, there's a notable difference. The Constitution, as I've mentioned, requires the amount of compensation to reflect an equitable balance between the public interest and the interests of all those who may be affected by the expropriation. Whereas Clause 12.1 requires the amount of compensation to reflect an equitable balance between the public interest and the interests of expropriated owners and expropriated holders. Now, there are 2 points that arise from this. The first is that expropriated owners and expropriated holders are just 2 examples of all those who might be affected by an expropriation. At this point, I'd just like to footnote the interests of mortgagees. The second point is that expropriated owner or expropriated holder are refer to someone who has already been expropriated. But because the order in which we consider whether it would be, whether it would serve a public interest or be for public purpose to expropriate altogether requires a consideration of the amount of compensation that would be payable. It could never consider the interest. It would always have to consider the interests of someone who is yet to be expropriated. So it would never be in the past tense. It would have to be in the potential future tense. And that is an important matter, because when the committee was reordering the sequence of events, unfortunately, it neglected to pick up this necessary change in tense. And the change in tense was important because it does reflect the reordering of the sequence of events and the considerations that need to inform the decision to expropriate. There is, of course, one instance in which the amount of compensation will be considered after the decision to expropriate has been taken, and that's when property is expropriated in an emergency. The emergency provisions are now contained in clause 20, urgent expropriations. There, the circumstances require property to be taken at once and for compensation to be determined as soon as reasonably possible, but within 30 days. Only in that case would the public interest need to be balanced against the interests of an expropriated owner or expropriated holder. But as a general point of departure under the bill, it would always be balanced against someone who is yet to be expropriated. I footnoted the interests of mortgagees in this part of the discussion because it ties into the concern raised by one of the members. I believe it was one of the members of the official opposition. What is the position of mortgagees under the bill? A mortgagee is someone who holds a limited real right in property to secure a loan. The person who receives the loan puts up their property as that real security. The person who holds the bond would usually be the bank. So the person who is considered for expropriation, the owner of the property, is someone whose property is subject to a mortgage and who owes money to the bank. The concern was raised that if the property is expropriated, what then happens to the obligations to service the loan? And what happens to the obligations or the right to receive payment without the benefit of real security? The bill addresses this. If an expropriating authority is going to consider all relevant factors to inform the decision whether to expropriate, the existence of a real right of security over the property in favor of a bank or any other bondholder would be a very relevant consideration. This is something an expropriating authority would need to bear in mind in determining whether it should expropriate the property. If the expropriating authority considers this and finds that the property is suitable for expropriation, in principle, it must invite representations from the mortgagee, that is the bank. The bank will then be in a position to tell the expropriating authority what the outstanding amount is on the loan, potentially what the risk profile is of the customer, any relevant information that would be necessary for the expropriating authority to consider. If the property is expropriated, I beg your pardon, as part of that analysis, the expropriating authority will then need to consider how much compensation would be just and equitable in order to satisfy the outstanding portion of the loan, so as not to leave an expropriated owner in a position where they will be worse off, because that would very seldom be just and equitable. So the amount outstanding on the bond would reasonably be expected to be considered in any analysis of what the just and equitable amount of compensation would be. If the property is going to be expropriated and the property is subject to a mortgage, the bill makes provision for a mechanism to ensure that the expropriated owner and mortgagee are able to address their own contractual relationship, their bond relationship, so that neither party is left worse off. The particular provision is clause 16, and what it provides for is a mechanism where the expropriating authority can pay out the amount of compensation only if there is agreement between the person who has been expropriated and the mortgagee. The agreement is for them to negotiate and is intended to serve the purpose of settling the owner's liability to the mortgagee. Once agreement has been reached, the expropriating authority will then pay out the money to the person whom the parties have agreed will receive that money. That's clause 16.1. If there is a dispute between the mortgagee and the owner as to how much money is owed, and the expropriating authority doesn't want to become embroiled in that dispute, the expropriating authority can deposit the money with the master of the High Court, and once the dispute between the two private parties has been resolved, the master will make a payment to whichever party the amount is owed to. So in that way, the bill seeks to protect a mortgagee who would have lost the benefit of the mortgage, protect the commercial interests of that mortgagee by creating a mechanism that's designed to ensure that the mortgagee will receive payment on the outstanding portion of the loan. You see, when property is if property is subject to a mortgage and the property is expropriated, the expropriating authority doesn't also acquire the mortgage. The mortgage is tied to the principal debt. And if the property is no longer in the ownership of the person who is the debtor, then the mortgage is meaningless. The expropriating authority doesn't acquire the mortgage because the mortgage can't be separated from the principal debt. So when the property is expropriated, the mortgage is terminated. It becomes valueless. And that has implications for the mortgagee, the bank. So clause 16 seeks to ameliorate that loss of security by guaranteeing some managed payment mechanism for outstanding debts on properties. There is one more issue I'd like to canvass, and I understand that my time is running out, and that is something I noticed last night when I was preparing. There was a provision in the bill which allowed a person who was about to be, or who was considered for expropriation, an opportunity to make a counteroffer to the expropriating authority in response to a notice of intention to expropriate. That provision has since been removed from the bill. What happens now is that after receiving a notice of intention to expropriate, the recipient must decide whether she accepts the amount of compensation or will dispute the amount of compensation. If that person disputes the amount of compensation, that person no longer has the ability to make a counteroffer. Instead, the dispute resolution provisions would kick in, and the parties must either mediate or go to court. And I wonder whether that is necessarily the best way to go about this. Because if mediation or resort to court is the only way in which a counteroffer can be considered or proposed, then it would be in the context of dispute resolution only that the expropriating authority can ever consider a counterproposal. It wouldn't have had the opportunity to consider a counterproposal before initiating a dispute. And I think perhaps there may be some benefit in revisiting that, because if agreement can be reached based on a counteroffer, there wouldn't be the need to rush to court or to convene a mediation. Chair, I have run out of time. There are a few other matters that are addressed towards the end of the written note that I prepared in paragraphs 32 and 33. I'll invite the committee to consider those matters, and I am very happy to make myself available for further discussions on these quite tricky points.
Thank you, Advocate Nadu, for taking us through the department's presentation. What I will then do, I will then invite honorable members to engage with the presentation. I've noted Honorable Pratasa. The floor is yours, Honorable Pratasa. Then it will be followed by Honorable Dango.
Thank you, Chairperson, and I'm glad to report that my power is back on, so I can speak to you with my camera on and not from the car. Thank you to Advocate Nadu's presentation. It was very thoughtful and well presented. However, there are still some issues I need to address, Chairperson, and I do understand that today we're really trying to jam a lot into 4 hours. There's a lot of discussion on this, but I know that our process will be lengthy on this matter. But you know, like yourself, Chairperson, I've also had my smattering of legal studies, and I do remember in my second year law of contract, our professor, the first question we were asked, I think it was Professor Reinecker, said to us, "What is the point of a good contract?" And I remember it went around the class asking, and people were saying to regulate the terms between the parties and various other things. And he told us that we were all wrong, because the point of a good contract is to avoid litigation. And so I think that we need to start at that point. Any bill should be looked at is, what is the potential for litigation in a bill? And I think that's always a good acid test about the quality of a bill. And I'm concerned that this bill opens up many areas of possible litigation. So to start there, and to go into the question I asked the academic panel earlier, and perhaps Advocate Nadu can assist us, is where is the protection for the simple owner of property that may well be asset rich but may well be cash poor, when a behemoth like the government comes along and says, right, we want to expropriate your property? What protection is there for such a person or business interest or whatever to defend themselves and come up with the resources to defend such an action? Is there any protection whatsoever in that regard? Then I come back to the issue around intangible assets. Now, I understand all the concepts around, immovable and movable property rights and intangible assets and intellectual property and all that sort of thing. And it was spoken that it would be very unusual for a government to expropriate something like intellectual property, something like business rights, something like a car, something like the glasses that you're wearing right now, Chairperson. But if there is no intention to expropriate movable and intangible assets, why not exclude them from the bill? I'm concerned about, if we look at the Asian tiger model, where the government arbitrarily came in and told people, we want you to repurpose your business from what it's currently doing to something else. Or where in some countries that have gone the socialist model, just arrived and expropriated businesses because they felt that they would be in the public interest. I'm very, very concerned about, if that kind of expropriation is not even contemplated, it's extremely unusual. Why on earth have it in such a wide definition in the bill? Why open the door for that type of expropriation? Because when you look at public interest, the definition of public interest that Advocate Naidu covered public purpose, but public interest specifically says whatever the commitment of the country at the time is towards, and it specifically says land reform. So it specifies there that public interest is about land reform. But interestingly enough, it says natural resources. Now, natural resources I understand to be land, water, minerals. Why on earth do you want to include intangible and movable assets under natural resources? How can intellectual property be a natural resource, which is that's the definition stated under public interest. So that's, if we can just get responses on that. And then under section 12, section 12C says that the preamble to section 12, subsection 2, says that the expropriating authority must not take into account a number of things. And one of the things that must not be taken into account is consideration of enhancements. So if somebody has bought a property, has improved the value of the property by building buildings on it or whatever they've done to improve the value of the property, that must not be taken into account by the expropriating authority, which would be completely unfair because it would open the holder of the property to a loss. Effectively, it would mean that they've overcapitalized on the property. And then also section 12, 3A says that you must look at the use of the property and whether or not there are any plans to develop it. Now, the point is, Chairperson, in the South African property market, people sometimes buy pieces of property for the purposes of speculation. They may not have plans to develop it, but it is their right to buy them and perhaps sell them later at a profit. Now, the minister earlier said that this bill would provide certainty to investors, but if investors have to consider if they're purchasing land for the purpose of allowing it to improve in value and sell it later, they would be dissuaded from doing so. And also, if they consider that I might own a piece of land in South Africa, but I may be exposed to massive litigation costs to defend my rights in that regard if the government decides to long and expropriate it, because we have such a wide public interest clause, which includes all property and not just land, that might well dissuade investment in property. And so these are the questions I just wanted to raise with Advocate Naidu, and I do understand it's a lot. So if Advocate Naidu cannot respond completely now, I fully understand that, but perhaps we could get written responses if you can't cover it all. Thank you very much, Chairperson.
Thank you, Tim. Honorable Dango.
Thank you very much. Minister, let me remind you and myself of District 6, of Vredendorp, of Sophiatown, of Clarewood, and other places where people were expropriated by the National Party government and they had moved into negative equity. Now, the question I'm posing now is really, I go back to the Salt River project of the Khoi and the San people. Who's going to be compensated in that issue with the Amazon development? If that expropriation takes place, and this needs to be given back to the people that were dispossessed originally, when there was no records, when there was no land register, when it was collective ownership. Where is the question of negative equity in that one for those people that were expropriated in 1652? Thank you very much.
Thank you, Honorable Dango, for those questions. Let me just check as to whether are there any other members that would want to engage. Maybe just one to two questions from my side. The section 12C. Section 12C. Am I correct advocate to say that Section 12C makes provision for nil compensation, and that it also makes provision for nil compensation to take place in a situation of where they come to the conclusion that it is just inequitable to use nil compensation if it is in the public interest, but also where there's an element of unlawfulness that was detected. Let me just read that. Section 12C, so that at least there is no confusion around that. But it makes reference to unlawfulness. I just want to read that section. Section 12C, Section 12C. It says it talks to, I think, it talks to it talks to it talks to compensation. So I just want to get a sense as to whether does am I correct to say that it does make provision for that? The second point that I want to ask is there no contradiction between just an equitable and the nil compensation? And what happens where there is no agreement, because the act also, the bill also makes provision for expropriation even before payment is made. But also the other question that I want to pose relates to mainly the public interest will be land reform and land distribution, and is the bill at the center of it? Those two aspects, considering the fact that that has been a topical issue, because we all agree that the fall of the subsistence farming in our country, whether we like it or not, was linked to the legislation that was passed from the 1880s. The first legislative measure that led to the fall of the South African peasant was the Cape Parliament was the promulgation in the Cape Parliament under the premiership of Cecil John Rhodes of the notorious then Grey Act in 1894. This was followed by the Union of South Africa in 1910, where some of the provisions of the Grey Act were incorporated in the Native Land Act of 1913. Because this act prohibited Africans to buying land and owning land outside the 7% of the land that was reserved for their occupation. So the question is the public purpose and public interest, which mainly will be land reform. Does it take into account the fact that there is a need for land distribution and land reform? Because in most cases we are where we are because of this history. I think also, just the last point, I think one of the authors involved in 1972 has argued that the development of mining capital in South Africa in particular was inextricably linked with the reserves, the so-called subsistence and informal economy that has been referred to, which to a larger degree also meant that you will have an established right commercial farming on one side, and on the other side, you will have a disintegrated rural economy in the form of Afghanistan. So, does at the center of the expropriation bill, does it take into account land redistribution and land reform? Thank you. Over to you, Advocate. If some of the questions are more political, you can give the minister, if the minister is still on the platform.
Thank you, Chairperson. Thank you to the honourable members. Chairperson, you first identified the answer to Mr. Brantiseth's question concerning section 12, I beg your pardon, clause 12.2c of the bill. Clause 12.2c of the bill excludes only unlawful improvements on the property from being considered in the amount of just and equitable compensation. So lawful enhancements would not be hit by 12.2. Right, so that takes care of that. As to the protection of a private property owner against the behemoth of the state, well, litigation is perilous, and litigating against an organ of state exercising a public power has those very features. And so the courts have developed particular rules to assist parties in a vulnerable position when trying to challenge the exercise of state power. The bill itself doesn't provide for things like funding mechanisms or legal aid. Other pieces of legislation do that. But what the bill has done to assist people who may be expropriated and want to challenge that decision is to ensure that the decision to expropriate cannot be taken in the ordinary course until after the amount of compensation has been agreed or decided or approved of by a court. So it's only after the process has run that course and the amount of compensation has been agreed on or determined that a decision to expropriate can be taken. Once that decision to expropriate has been taken, and if it has been taken affirmatively, and the owner or the expropriated owner wants to challenge that decision, it will then be open for them to go to court. Sequencing it in this way is important because after an amount of compensation has been determined by a court, it would be open for an expropriating authority to decide, actually, I don't want this property. I don't want to pay that much. And so I'm not going to expropriate it. So there may no longer be a need for the subject to challenge that decision. So the way in which the bill assists the subject is not by providing mechanisms or means for challenging decisions to expropriate, such as funding or other resources. What it does is sets out a process so that all relevant information is before the decision maker to make an informed decision. And if the decision is taken, which is adverse to the subject, and the subject wants to challenge that decision, the bill guarantees the subject a pathway to the courts in clause 19.6 to approach a court on any matter relating to the application of this act. But the bill does not provide for measures to assist a challenger financially. That's not the purview of the bill. There are other pieces of legislation and other organs of state like the Legal Aid Board, which would serve that function. Intangible assets. The honourable member did refer to some movable property like a car, which could be expropriated, and questioned whether it should ever be expropriated. I recall one of the academics, the doctor, listing cars in the category of movable property that could be expropriated, and I think that's correct. In the event of an emergency, it may be necessary for government to requisition vehicles to move people from flood areas or whatever the case may be. So I don't think cars are necessarily off the list. But intangible property does pose some interesting questions. Property is increasingly becoming dematerialized. We deal with things like bitcoins and shares and I suppose one can commodify your Instagram account or whatever the case may be. And those would still be assets and intangible property, arguably intangible property recognized under the Constitution. Just because something is intangible property doesn't mean that it will necessarily be expropriated or even be suitable for expropriation, because it may never be capable of serving a public purpose or being in the public interest. So going back to what the doctor said earlier on, if one looks at the definition of expropriate, or rather the power to expropriate in the Constitution and the riders on that power, one can, by process of interpretation, eliminate certain kinds of property as a matter of practicality from the scope of the Act. There may well be a need to expropriate immovable property. I can't prognosticate now as to what that need might be. There may be, but that isn't the point. The point is that the bill shouldn't be under-inclusive, lest it exposes itself to constitutional challenge on that basis. Let's say that there is, I'm trying to think of a counterfactual. Let's say there is a need for the state to acquire a company which has become a monopoly in an industry. There's an old example in Canadian law. I think it's Manitoba versus, there was a Crown Corporation which effectively had a monopoly on fishing. And the Crown Corporation, by act of the legislature, vested those rights exclusively in the state. So the state effectively acquired a monopoly on fishing. And that was considered an expropriatory act, but it was done for public benefit. It could be done in our country because there may be monopoly abuse of a certain industry. And it may be abuse in a manner that impacts very negatively on large swathes of the public. Government may want to step in to expropriate, and of course that will be a policy question whether it does. From a legal perspective, the bill shouldn't too hastily crowd out those prospects. to make it impossible to expropriate if the circumstances so require. I didn't quite understand the member's question about trying to rely on the public interest definition in clause 25.4a of the Constitution to justify expropriation of intangible property. The first point is that public interest is not exhaustively defined in section 25.4a. It includes the nation's commitment to land reform, reforms to bring about equitable access to natural resources, and an intangible asset wouldn't be a natural resource. I accept that. It might not be related to land reform, but even if it is neither of those things, it may be notionally possible for intangible property to fall under the remainder of public interest as a variable, the remainder which is undefined in the Constitution, because what is defined is purely included and not an exhaustive list. It is probably more likely that if intangible property were expropriated, it would be in terms of legislation which would tightly define the nature of the property and the purpose of the expropriation. And so the expropriation is more likely to be a public purpose expropriation than a public interest expropriation. The only distinction I can think of off the cuff of my head is where the intangible property is expropriated for the benefit of and for use of a third party, and a direct transfer is made rather than a transfer via the state. So I'm going to have to give this some thought, but as a matter of principle, my answer would be that I don't think the bill should crowd out the room for expropriating intangible property, given how quickly the use of intangible property has permeated our lives and will continue to do so. I think increasingly people will start holding more intangible property than tangible property. And one wouldn't want to tie the state's hands unnecessarily or unduly if expropriating that property could serve a public interest or be for a public purpose. On the matter of expropriation for nil compensation, I accept that there are some people who are property investors who will want to hold property for purely speculative purposes and to benefit from the appreciation in value of the property, nothing more. The bill isn't intended to target those people. What the bill in section 12.3a is intending to target is the use of property that could serve a productive social potential, but which is lying fallow and isn't being used by the owner. And the greater good, the greater public good would be served by making that asset work for the public. And expropriation is the mechanism to acquire the asset for that purpose. I think one always has to bear in mind that the purpose requirements, the public interest, public purpose requirements drive the lens through the suitability of any particular property for expropriation. So the example that we were given of a private property owner holding assets for purely speculative purposes, where those assets wouldn't serve a public purpose or be in the public interest if expropriated, doesn't present a controversy. I hope I've answered the members' questions. And if I haven't, then Chair, through you, I'm happy to provide a written note.
Thank you, Advocate. I hope that members are happy with the responses that you have given to the questions that they have given. And I see no...
One more point I wanted to raise, which is in response to you, a question which you raised about whether expropriation can occur before the payment of compensation. Yes, expropriation can occur before the payment of compensation in the ordinary course, but the right to acquire possession of the property will vest in the expropriating authority only after compensation has been paid, never before. So an expropriated owner of property won't lose his house and won't lose his house without any compensation, to put it crudely. The only instance in which, under urgent expropriations, the duty to pay compensation after expropriation is spelled out in the bill, and it must be paid within 30 days, as soon as reasonably possible and within 30 days. Chair, I believe there's a question.
Is it still necessary to talk about expropriated owner, not an expropriatee? How can you become an owner when your property has been expropriated? Let me get to another question. Tim, what is it?
Yeah, Chairperson, look, I appreciate Advocate Naidoo's responses. I don't think they get to the nub of the matter on all things, but I do appreciate where he did assist. I'd just like to remind the committee of the relatively recent example of Zimbabwe, where farms were expropriated because that government felt it was in public interest to do so. And that crippled that country's agrarian economy. Because one may look at a farm and say there are many fields here that are not being used, they're lying fallow, but of course they may be intended for future rotational use. And I'm just very, very concerned that the advocate says this is not controversial. Land that is lying fallow may have future use and not necessarily use right now. And I just think that we should really be mindful of our northern example as to how we can destroy an economy through this purpose. Thanks a lot.
Thank you, Tim, for that. Advocate?
Thank you, Chair. I wouldn't want to tread in the realm of policy. That's not my field of expertise.
Okay. All right. Then I think less than...
Chairperson, that's a very good lawyer answer. Well done, Advocate.
Yeah, let's then take this opportunity to defer to the minister if he's still on the platform. Minister, any last word from you?
Thank you, Honourable Chairperson, and thank you for all the questions, and also to Advocate Naidoo. Honourable Chair and members, we will be on standby for any further engagements with the Portfolio Committee. We know that this is all still work in progress, and we will be there to assist with any other further explanations. I do wish to request the committee to consider the clauses Advocate Naidoo made a reference to, because even though it's passed the National Assembly, the NCOP Select Committee present us with an opportunity to reconsider those clauses. And I hope that the committee will consider the proposals from the department while the bill is now processing through the NCOP. So once again, thank you for the opportunity. Thanks.
Thank you, Honorable Minister, for that. Let's then check with Dr. Aniki in terms of the process plan. Just before we go to the in-house.
Sorry, Chairperson.
Yes, Tim.
Chairperson, thank you for your indulgence, Chairperson. The Minister's made a very good point. Advocate Pillay did point out some of the clauses that he was concerned about. Is it possible to get a document from Advocate Pillay so that we can take those into consideration? And I do appreciate the Minister's willingness to improve the Act, even in the NCOP state.
I think that's a good point that the team will work on. Dr. Anike, can you just outline I think let's probably then finish this and then we'll then deal with the minutes. But I think what is quite critical is that following this, then definitely we will be waiting for the engagement at the level of the legislatures, the briefing at the legislatures. But more than that, I think we'll then allow that public hearing exercise to take place, and then we will then, when we are ready, as the committee, then deal with the report. But members must be ready to be part of the briefing at their respective provinces. Let me take this opportunity to thank the Minister and the team for the work that they've done by honoring our invite and also briefing the Select Committee on this expropriation bill. Will definitely take the hand extended to us as a committee. Usually when the briefing takes place at the level of provinces, we expect the team to be able to send their reps so that they make it much more easier for us, even in terms of briefing, to help us. So we are humbled by that gesture, and then also take this opportunity to thank members of the public for attending, members of the media, the committee staff for the attendance. What we will then do, we will then deal with the next items on the agenda, which is the minutes of the previous meeting. But the team, they are free to excuse us because we are now dealing with the in-house issues, the minutes. Thank you. Can we deal with the minutes, Doctor?
Yes, Chair, I'll share in a moment.
All right.
Chair, Member Mokgethi, I'm not too sure if we're allowed to sit or can you also be excused?
No. You are free to exit, Member Mokgethi.
Thank you very much, Chair.
Thank you. We are dealing with the minutes of the. We are gone again. Let's just check. We have three sets of minutes that we have 3 sets of minutes that we must adopt. Yeah, the first minute is that the minutes of the 30th of November 2022, where we were hosting the Department of Planning, Monitoring and Evaluation. Those are the attendees that attended the meeting. Can we go down? Can we go down? Dr. Clark, your screen is not moving.
I'm moving on my side.
Okay. On our side, it's not moving.
Do members see point number 4 at the moment?
No, we are still at attendance, the briefing by department, right at the top.
Let me try to stop and share again.
Mhm. Yes. Can you move up? Are you moving?
Yes, can members see movement?
There's no movement. Or am I the only one? Let me check with other members.
No, Chairperson, it's not moving.
It's not moving, Chairperson.
Where's Enrico? Enrico?
Okay, I'm gonna screen it from my side quickly.
Thank you very much, Enrico.
Okay, Nico.
Actually, while Enrico was busy bringing up the minutes, I just want to confirm, Chair, yes, that 15th of March is the date for when the permanent delegates will brief the respective provinces on the bill. Members would have seen that the adverts for the bill as for input on the bill has gone out. We are currently sitting on over 10,000 submissions, Chair. So so we've received a lot of inputs on the bill so far. So I just want to give that feedback.
Yeah, the 15th of March. Okay, beautiful.
Yes.
Good. Thank you. So members will be in their respective provinces to brief to brief the provinces.
That's correct.
All right. Thank you. Yeah, let's move. Enrico, that is the 30th of November, where we dealt with the Praza. The attendees okay? All right. Those are our guests. And then the opening remarks. As the overview, any correction on that? And the comments and deliberations? We have an outstanding date with Praza in Cape Town. I think our next meeting, we must go and see the central line. I think that's what we must do, because we were informed that there is tremendous progress on that. Any correction, members? In the absence of any correction, can we then get a mover for the adoption of the minutes? Set through reflection.
I so move, Chairperson.
Thank you, Honorable Dango, for moving. Can you get a second there?
I second, Honorable Chairperson. Thank you.
Thank you, Mshodi. Can we get to the next set of minutes? The minutes are duly adopted. It's suspected it will be planning and monitoring minutes. Yes, this is the minute. This is the we had two meetings that day. It was in the morning and in the afternoon. So in the afternoon we were hosting Department of Monitoring, Planning and Evaluation. Those are members that were present. Committee staff. Those were the open remarks that were made. Apologies. Those were the issues that were raised, and then comments and deliberations by members. And then the requests that were made, can you just go up a bit? Can you just go up a bit? Yes, this is the request that we made, a report on the investigation into irregular appointments related to the period between the 1st of April 2018 and 31st March 2020. A report on its assessment of progress towards attainment of the NDP targets identified during the department's medium-term strategic framework. Let's get feedback whether we have received this. You can give us a feedback next week when we meet. Those are the minutes that were adopted, and then the oversight report that we dealt with. We have an extending meeting with Solplachi. Thank you, honorable members. Any in the absence of any correction or addition, let's get a move for the adoption of the minutes. Can you get a mover, Honorable Apleni?
Thank you very much. I move to adopt the minutes.
Thank you, Honorable Apleni. Can you get a second?
I'll second the chairperson.
Thank you, Honorable Dango. The minutes are duly adopted of the 30th of November 2022. The next set of minutes will be the minutes of the 8th of February 2023, where we hosted the Department of Transport on the briefing on the economic regulation of transport bill. Those are the members that were present. Those are the members that were present. So the members, the guests that were in attendance, and also our team from the committee. Those were the issues that were raised. The briefing was by Advocate Mashaya, the team. Those are the issues that they raised in terms of the single transport economic regulator, the economic regulation of transport bill, the implementation plan, organizational design, and also steps that to be followed. And then those are the observations, comments, and deliberations that were made by members. Can we get a move of the adoption of the minutes of the 8th of February?
Thank you, Honorable Chairperson. I move for adoption of the minutes.
Thank you, Honorable Mushori. Can you have Honorable Apleni? Where's Tim?
Okay. Okay.
Tim, can you second? You are there.
Chair, I'm happy to second.
Thank you, Honorable Brattaseth, for seconding. Honorable members, the minutes therefore are duly adopted. And then is there any update, Doctor, on the overseas trip, our study tour?
Yes, thank you, Chairperson. Soon after our meeting in November, we liaised with DIRCO in relation to the study tour. So the request went out to both England and Germany to as part of the study tour. England has come back favorably. We are at the stage now where we are busy with England discussing the thematic areas to be covered as part of the study tour. Germany's response, however, Chairperson, is that they're not able to host us at the moment for a number of reasons. They are at that time also hosting the Defense Committee for a study visit. It's the Easter holidays and the Bundesrat is not in session at that time as well. There's also some financial implications that they asked us to consider. They then suggested, Chair, that the alternative is to come and visit them to visit Germany between 22nd and the 26th of May. On our side, that creates some uncertainty, Chair. Firstly, we don't know what the parliamentary program will be like at that time. And both committees are busy dealing with legislation that we will have to prioritize over that period. So we have gone back to England to ask if we were to extend the stay in England and then include visits to projects outside of London, if they would be able to incorporate that in their planning for the study visit tour. And so we are still waiting on a firm response from them in respect of the extended visit, Chairperson. So at the moment, just to confirm, the proposed dates was that 3 to 6 April in England, 11 or 14 was intended for Germany, but now we've asked England if we can then just extend the stay to include the 11th to 14th of April in England as well, Chairperson. I'd be comfortable, and if I might, Chair, if we give England out till probably the end of this week, and then we'll follow up again in respect of the proposal for the extended stay in England. Yes, I'm happy to hear the committee's feeling on that.
Chairperson,
Ambassador.
yeah, it's in fact the United Kingdom and not England. So we'd be extending the stay to either Scotland and Wales and other areas. The British ambassador has indicated that he will assist in any way that he can if we contact him for assistance. I know that the officials can't do that, but if they want to, I can reach out to him and say, please assist. Thank you.
Thank you, Ambassador, for that gesture. Okay,
Chairperson.
Yes.
Chairperson, my question to Anneke is if when she says 3 to, did she say 3 to 6 April? And if that is the case, or is the 3rd when we would leave, or the 3rd when we would be in England? Well, what would the date of departure be? It's just important to myself and I think my colleagues, Yakulont and Sonia Boshoff.
If I may, Chair?
Yes, sir.
Yes, apologies, Member Botha. So 3 to 6 will be when we are in England. So the planned departure would be the 1st of April 2023.
1st of April.
Yes.
1st of April, okay. Well, that is the date that we'll be leaving, okay.
Yes, and
Chairperson, yeah, you may have seen in the media, Chairperson, but that is the date of our Federal Congress. It starts on that day, so that might exclude maybe Ambassador Dango will be very happy, but it could then exclude myself, Honourable Boshoff, and Honourable Lont. I don't know if it's possible the trip backward a bit into April. But yeah, that would be very, very problematic for us if the committee would like to have full representation. I suppose it's not out of our hands now.
I think that's reasonable. Let's allow the team to in planning to factor those factors into consideration, and probably in our next meeting we'll get a feedback.
Yes, definitely, Chair.
Thank you, Doc. But the last point, just to update the members, one of our members, as you all remember, Honorable High, had to undergo an operation which did take place successfully. So he's at home recuperating. So we are with him in our prayers. Very soon will be joining us. Thank you, honorable members. I believe that we have exhausted our agenda, Doctor.
That's correct, Chairperson.
Thank you. Let me then take this opportunity to indeed extend a word of gratitude to all of you, honorable members, and also our staff for the job well done. It was a marathon, but because of the support that we have from the management team, we were able to pull it off. But also to our guests from the provincial legislatures, the PMG, our legal advisors from the legal department. Your presence indeed is appreciated. Your assistance is well received. And on that note, honorable members, the meeting stands adjourned. Thank you.